Good morning, everyone, and a warm welcome to this online policy briefing organized by the European Policy Center to discuss with Didier Reynders, European Commissioner for Justice, about the potential risks of the coronavirus pandemic for liberal democracy in the European Union. We are living through a moment of great shock and paralyzing uncertainty. COVID-19 has turned dystopian novels and movies into reality. And as the situation appears to be spiraling out of control, we're left to brace for a series of cascading crises whose magnitudes, speeds, or names even, we do not know yet. When nothing is impossible anymore, everything is possible, including greater powers for European governments to close borders, enforce quarantine, broaden state surveillance, track infected people, detain citizens indefinitely, or limit the freedoms of assembly and expression. Many argue that extraordinary times call for extraordinary measures, and that such actions are not only needed in order to contain the spread of the virus, but also protected under international law. Yet, many others criticize such bills, which give some EU governments unchecked powers without a sunset clause, as unacceptable attacks on the foundation of liberal democracy. So the question now is whether the current public health crisis is becoming an excuse for, well, virtually dictatorship in the EU. Can liberal democracy withstand such pressures, or will the pandemic redefine our norms? How do we ensure that the laws passed in response to this crisis are strictly necessary, proportionate, and temporary in nature, as well as in line with our democratic values and principles? And what role can or should the European Union play to help liberalism survive and recover from this pandemic? Well, Didier Reynders, European Commissioner for Justice, is here with us today and will address these and other issues. Commissioner, thank you very much for our invitation. I will shortly and kindly ask you to make a brief introduction, and then I will turn to our audience and invite our participants to ask questions and make comments. Speaking of participants, I would just like to remind everyone that in order to ask their questions, they can click on the green hand icon that they can see on their desktop, and then I will come to them during our Q&A session. So, Commissioner, in your Commission letter from last September, the Commission President von der Leyen stated that, I quote, "What we do now will determine what kind of world our children live in and will define Europe's place in the world." So, in light of recent democratic developments during the ongoing COVID-19 crisis, what kind of legacy do you think that we are building and living for future generations? Commissioner, the floor is yours.
Thank you very much. And first of all, thank you very much for your invitation. And it's a pleasure to take part in such a webinar about the liberal democracy under threat in the EU, because it's a very important issue. It was possible for the member states of the European Union to enter into crisis with a liberal democracy. And we need to be sure that it will be possible to go out of the crisis with also a liberal democracy. It was not the same in all the regions in the world. So we are specific in this situation with others, of course, but it's very important to try to work on it also during the crisis. And the liberal democracy is not different from the common values of the Article 2 of the Treaty on the European Union. In fact, some months ago, we have had many debates about the European way of life. In my mind, the European way of life is the Article 2, to protect freedoms with the rule of law, democracy, and fundamental rights. And indeed, democracy, rule of law, and fundamental rights are core values of the European project, and they bind us together, and we must uphold and promote them also during such a huge crisis that we are living in. And they go hand in hand, so that if you weaken one, the other will suffer. As Justice Commissioner, like you said, I will always be vocal on this in order to assure the resilience of Europe, especially in these exceptional times. Democracy requires holding regular elections by direct and universal suffrage and through a free and secret ballot. Moreover, it requires that citizens are treated equally and have an opportunity to form and express their views without coercion in a fair democratic debate. The rule of law in particular ensures that institutions are equipped with those safeguards necessary for democracy to resist challenges which might occur in any state, especially in the current crisis. And fundamental rights are also essential. Free and fair political campaigning, safe from manipulation, are framed within the freedoms of associations, assembly, and expression, and the other fundamental rights, including data protection and the procedural safeguards. Free and fair elections depend on all our EU values being upheld, including a free and plural media, fair democratic debate and electoral campaign, and most of all, on citizens who are informed and empowered to participate in the political process and institutions that they trust. And so, of course, during the last weeks, we have seen some developments. Over the past weeks, several EU governments took emergency measures to address the health crisis caused by the outbreak of the coronavirus. Governments, in principle, need to have the necessary tools to act rapidly and effectively to protect the public health of our citizens. The Commission, I want to insist on it, fully supports member states in their fight against the epidemic. So it's quite normal in exceptional circumstances to take some exceptional measures. We must respond to the crisis in, I said, the open way, in full respect of our fundamental principles and values as set out in the treaties. Any emergency measure needs to be taken with full respect to the rule of law and fundamental rights. They must uphold democratic principles and must be limited to what is necessary and strictly proportionate. They must not last indefinitely. Governments must also ensure that such measures are subject to regular democratic scrutiny. Parliament, press, justice, there are different ways to organize an oversight on the different measures taken. Let me assure you that the Commission is closely monitoring the measures and their impact, in particular on the rule of law, on fundamental rights, and on EU law. Measures affecting the democratic debate and free and fair elections are also being monitored. I'm making sure that we are looking at the situation in all member states. I insist on it, an equal treatment. This is indispensable for ensuring fair and equal treatment among member states. We also need to look objectively at the overall system of checks and balances, which is specific to each member state, and at the concrete impact of these emergency measures on the ground. This will enable us to identify potential next steps. In this framework, the Commission is analyzing the Hungarian legislation regulating the state of danger, because it's the name of Hungary, of the state of urgency, the state of danger, which is a matter of particular concern for me. Concerns have also been voiced in the European Parliament by the OSCE Office for Democratic Institutions and Human Rights and the Council of Europe, but also by others. I also closely scrutinize how the Hungarian authorities will apply this legislation. This is true for the individual implementing measures, but also for their combined effect. I will pay particular attention whether and how any of these measures affect EU law. Where this is the case, the Commission should take action as necessary as we have already done in the past. So it will be very important not just to check the law, but to analyze the situation with all the measures taken on the basis of the law. And that's the most important element in the future. As regards Poland, the presidential election planned for 10 May have been criticized for being organized under circumstances that make political campaigning challenging, to phrase this carefully. Were the Polish government to call a state of emergency, the elections would be postponed under the Polish constitution. So we will also monitor very closely the situation there, but it's a national decision to organize elections. And let me stress in this regard this point, that while it is for member states to decide whether to continue with or postpone planned elections in the current context, where they decide to proceed, they should be consistent with their obligations under international law and with their constitutional arrangements to guarantee free and fair elections. This is essential to ensure the democratic legitimacy of those in power. And it's very important to remark that if it's possible to organize election in crisis situation, it's not just the organization of the election with the problem. The problem is a fair and correct process also for campaigning before the elections. And of course, during the crisis, it's quite difficult. To conclude, the cases of concern show how important it was that a large number of member states adopt a joint statement on emergency measures at the beginning of this month. They call on the Commission to monitor the emergency measures and their application to ensure that the fundamental values of the Union is upheld. As Justice Commissioner, I will fulfill this task with determination and protect liberal democracy in Europe. And before to answer to your question, I want just to insist that we have now, for the first time, the opportunity to present an annual report on the rule of law. It will be in September during the German presidency. We'll go to the Commission with a report, and we are in the process for the moment, and then to the European Parliament also, and the Council. Of course, it's very important to engage the dialogue on the rule of law in all the member states with all the different institutions at the European level. We'll go also to the national parliaments and to the civil societies in the different member states, because the goal of such an annual report is to install a real culture of rule of law, a real debate on the rule of law. But during the crisis, we have decided, on my proposal some 3 weeks ago now, to start 2 monitorings. I don't want to repeat what I have said about the first one on emergency measures, and it's very important now to control all the measures taken on the basis of the different laws in 22 member states about the state of urgency or state of danger. But I want just to add, and we will have maybe some question on it, that we have also organized a monitoring on the data protection. It was possible to publish last week with some colleagues like Thierry Breton recommendations on the common toolbox to use the smartphones in the way to fight against the pandemic. And now we'll try to publish this week with the support of the European Data Protection the European Data Protection Board and with the national authorities involved in the data protection, a guidance about the use of possible apps, because it must be with the consent of the people, it must be with a real trust of the citizens in the way to use those apps to fight against the pandemic, to inform maybe better the citizens, and also to inform the citizens who were in contact with infected people in the last 10 or 12 days. So we'll continue to work on it this afternoon, and I'm sure that it will be very important to prove that during such a crisis, it's possible to stay online with our values and to stay online or with our regulations like the GDPR. It's very important to show that. Of course, there are some exceptional circumstances, there are some exceptions in all our regulations, but we need to fix the framework and to fix the limit. So thank you for your invitation. I'm very pleased to listen to your questions.
Great, thank you so much, Commissioner. I would just follow up with a couple of questions, if I may, before we turn to our participants. You mentioned exceptions, and here I wanted to ask you, how do we define a state of emergency? And Do you think that we risk finding ourselves in a perpetual state of emergency from now on, at least in some member states?
But the state of emergency, it's possible in many constitutions. So we don't have specific rules at European level about that. But in all the member states, there are some possibilities to decide it. And I said in the last weeks, we have seen at least 22 member states deciding or the state of emergency, or like in Hungary, the state of danger, or some exceptional situations with a new relation between the parliament and the government. All in all, is to give more competences to the government to act very quickly. And so it's possible to think about that. We are not in a war situation, but we are in an exceptional situation due to the sanitary situation. And so it's logical to do that. But when you are doing that, it must be for a limited period of time. That's the first element. We need to be sure that after a period of time, it will be possible to go back to a normal situation.
Sure, that's the question. It's the exit strategy from this emergency state that is sometimes concerning.
No, but it's true, and it's the reason why we are concerned by the situation in Hungary, to give an example, because there's no predefined delay for the state of danger, and it's just in the hand of the government to stop the process. But of course, it's too early to say that it will be too long. We're at the beginning of the process. And again, the most important thing is to be sure that we have the capacity to monitor not only the law with the decision to enter in the emergency system, but to monitor all the measures taken on the basis of the law. And you know that in Hungary, is to give an example, the first element is that it's possible now to suspend some laws, but some laws are just a transposition of an EU directive. If it's the case, it's a suspension of the European law. So we are concerned by that. We will monitor that in Hungary, like in all the other member states. And the second concern, it's about the new incrimination for the dissemination of fake news during the pandemic. If it's just that, it's just to fight against pandemic, why not? We have the same regulations in other member states, but I have seen the demonstrations in the last hours in Bulgaria due to the fact that a doctor have sent some messages about the fact that there is a lack of medicine in the country. Is it a fake news? It's maybe the reality. So we need to protect the freedom of expression, the freedom of speech, and the freedom of press. So the monitoring of the measures taken in the application of the law will be very important, and the monitoring of the different investigations organized by the prosecutors is also very important if you have a new incrimination.
Okay, so now it's great that the European Union is monitoring these developments, and if let's assume for a second that we do find irregularities, and we do find things which are not really in line with democratic rules and principles and procedures which are expected of all member states. In that case, do you think that the EU has the appropriate tools to be able to uphold the rule of law across the Union?
We have some tools, and first of all, we are using the infringement proceedings when it's needed. And we have organized a process in many different cases, but also about the rule of law. If I may, about Poland, in the last months, we have decided to go to the Court of Justice about the disciplinary procedures against judges. And we have asked interim measures. And it was possible to see some days ago that the court have decided to ask to suspend all the disciplinary procedures before the specific chamber in the Supreme Court in Poland. So it's possible, and we will continue to introduce some infringement proceedings if we have the good arguments to show that there is a real breach to the rule of law, to independence of judiciary, to give two examples, or to the European law. We are doing that all the time. So that's the first element that we have. The second one is, of course, the Article 7 of the treaty. And you know that there are two procedures for the moment on the request of the Commission about Poland and on the request of the Parliament about Hungary. And I've said to the Croatian presidency that we are very open to make a new state of play, or maybe later to organize new hearings about that. But there are some limits in such a procedure due to the qualified majority and sometimes unanimity needed in the different steps of the process. But it's very important to push pressure through those procedures. And then I'm sure that if we want to have a more efficient tool, it will be very important to go back to the discussions about the conditionality of the funding of the member states. You know that during the first discussions about the MFF, the future MFF, multi-annual financial framework, the Commission has proposed to introduce such a conditionality between the funding of some policies and the full respect for the rule of law. Of course, it will be important to continue such a discussion, certainly after such a crisis, to be sure that it's possible to organize a real solidarity in Europe, but of course to organize such a solidarity with all the member states having a full respect for the fundamental rights, the rule of law and democracy. And it's a huge debate, of course, for the moment at the Council level, but there are more and more member states in favor of such a procedure. And I want just to conclude saying that it's of course fine if it's possible to have a conditionality, but maybe with other rules than in the Article 7. So I mean with a reverse qualified majority and no more the qualified majority or unanimity to take a decision.
It's interesting that you mentioned the funding, because we do have actually a question from our participant, from James Cantor, who runs the EU Scream, and I quote, he's asking you, I would like to ask Commissioner Reynders whether he supports removing EU budget support from countries like Hungary that are using the COVID-19 crisis to damage democratic norms further. How soon should removal of EU support happen, and what components and amounts of the EU budget should be withheld from states like Hungary?
In the proposal of the Commission for all the member states, it's a general proposal to the Council, and it's in discussion in the Council, it's possible to suspend or to limit the funding of one member state if there is a general breach to the rule of law. Of course, we need first to see that it's possible for the Council and the Parliament to agree on the proposal of the Commission before to use such a kind of conditionality. And if it's possible to do that, I said, with a reverse qualified majority, to don't be blocked by a small minority in the Council. So it's very important to go further with such a proposal. But there's also another concern. If we suspend the financing, the funding for one member state, we need also to take care of the beneficiaries. Because, of course, when you speak about the capacity to suspend or to block the funding for one member state, it's not to block the funding, to give to example, to the farmers, or to block the subsidies to some NGOs involved in the civil society to defend the rule of law. So if we suspend, we need to find a way to organize another process than through the national authorities. And for the moment, the most difficult discussions, of course, it will be the task of the Council and the Parliament to agree on the proposal of the Commission. If it's the case, of course, I answer to the question. In Hungary or in other member states, we will monitor the situation everywhere. It will be possible to take some financial decisions. Okay. But for the moment, we don't have such a capacity.
Right. And then you mentioned an annual report on the rule of law, which will come out in September. And I remember, I think in 2014, we also had an EU-wide anti-corruption report, which we waited for a long time. And then it promised a follow-up report every 2 years, but it never happened. So what can we expect of this report monitoring the rule of law? Will it simply name and shame, or will it also include recommendations to which individual member states will have to be held accountable? How will it work?
I don't want to be too long about that, but it's a long process. I've started in another capacity as member of the Geneva Council and Minister of Foreign Affairs and European Affairs in 2016 to discuss about a possible peer review on the rule of law. In the same year, in 2016, we have seen also some discussion in the Parliament about that, the European Parliament. And it was just last year, in July, that it was possible with the former Commission to have a communication organizing an annual report on the rule of law, a new mechanism. And so to answer to your question, first, it will be an annual report. So be sure that we will organize a process every year. It will be a process, permanent process, year after year. The second element, we will go back in such a report, for the first report, on 4 issues. Independence of the judiciary, because we have seen that it was maybe the most important element. The rule of law, that means that you have a society managed by law, but if you need to ask the full respect of the law, you need to go to an independent and qualified judges. If you don't have the independence of the judiciary, you don't have rule of law. Then the fight against corruption. So we'll go back to the fight against corruption in this report this year. And the third issue will be the media pluralism. And the fourth, a more general approach about the checks and balances. And it will be a description of the principles. What are the rules? Because we are speaking on the rule of law, the treaty, the case law in the European Court of Justice in Luxembourg, but also case law of the European Court for Human Rights in Strasbourg. Then the description in all the member states of the situation, and a risk-based analysis to go to conclusions that mean recommendations to ask to the member state to change something, and if it's needed, to introduce maybe some infringement proceedings. So to answer to your question, it will be not only a description, not only a risk-based analysis, but also with some recommendations and to exchange the best practices, but also to point out the positive evolution and the negative evolution. And it's the reason why I don't want to have a report just to put in the library. I want to have a report to start a real debate. And we'll go back to the Commission, of course. It will be a report from the Commission. But then we'll organize a debate in the Council, in the European Parliament, and I said before, at the national level and with the civil society. For the moment, we are in a consultation with the member states about the preparation of the report till beginning of May, and a consultation with all the possible stakeholders. If you want to take part, it's possible. We have published our consultation on the website of the Commission. And of course, we want to have a good contribution from the member states about the situation in all the member states, but also from all the different stakeholders, classical, like the Council of Europe, or you spoke about corruption, the Greco in the Council of Europe, or the Venice Commission, or FRA, the Fundamental Rights Agency in Vienna, but also from different NGOs and partners in the different member states. So it will be a real new process. It's quite exceptional because you know that we have had many discussions in many years about the Maastricht criteria, about the budgetary situation, the structural reforms, but not so much about the values. And it's the first time that we start a real discussion about the values, and it's time because we have some indication of bad evolutions in some member states, and it's maybe more dangerous during the crisis. I didn't hear you.
I had muted myself. I apologize. So just to say that at this point, I would like to invite our participants to ask questions. I already have a long list of written questions in front of me, but they are very long. So I kindly ask those who are writing me questions to keep their queries short. But I also want to encourage people to raise the hand so that we can hear some voices on the other side and know that we are not alone here. In the meantime, while people are raising their hands, even some of those who have written me the questions, it would be good if you could pose them yourself. I will just give you the next question on my list, Commissioner. So Jakub Semrau is asking, what are the precedents for new uses of a reverse qualified majority where it had never been used before or foreseen by the treaty?
But if you have a reverse qualified majority in the budgetary procedure, and you know we are discussing about now the European semester, due to the bank crisis and the sovereign debt crisis, it was possible to reinforce the mechanism. And due to that, the adoption of the different conclusions in the European semesters, it's a question of seconds at the level of the Council. There are no discussion because after the preparation of the document by the Commission and of course some exchange with the member states, it's possible to have a real support of the Council due to the fact that it's very difficult, of course, to go to the Council and to try to organize such a reverse qualified majority. You need to convince a qualified majority of the Council to change the way to present a document. So, of course, it's better when it's in the treaty. Here, it's a proposal of a new regulation by the Commission, and in the regulation, it's possible to use the same process. I have seen many years ago, the first discussion was just the qualified majority. It was a huge change, because if you use just unanimity, it's not needed to take part in the discussion. It's just possible to wait and at the end to say no. And you don't have unanimity. With a qualified majority, we have introduced the idea of a real discussion. You're saying that it's better to take part in the discussion, to have an influence, and not to wait till the last moment just to refuse because you have a veto right with unanimity. But also with the qualified majority, we have seen that it's possible to block the system with a minority. It's possible to organize a minority among some member states to block the system. So in some question, it's very important to try to reverse the situation and so to say, no, you need to convince a qualified majority. But it's true, in the question it was said in the treaties, yes, it's better when it's in the treaty, but it's also possible to organize that with a new regulation, and it's a proposal of the Commission about the conditionality.
Right. I would now like to give the floor to John Palmer. Natalie, will you be able to John
Hello,
Palmer?
yes.
Oh, yes.
Yeah. Hi, thank you. Mr. Reynders, that was an extremely helpful presentation. I was in a previous existence the political director and the founder of the EPC, so I appreciate very much following the thinking of the Commission at the present time. My question concerns a legitimate problem that all member states have in combating the virus, which is about detecting the movement of the virus, not merely with people affected, but people who might have met other people who could have been affected. And there are new technologies which are available to give the authorities the capacity to follow everybody we meet, everybody we discuss with, everybody we might have a social exchange with. I'm wondering whether, in view of the real problems that we're facing, but the potential human rights questions, you've thought at all about some principles that might govern the use of these new technologies.
No, but thanks for the question, because I said at the end of the presentation that we are also monitoring the situation about the use of new technologies in the fight against the epidemic. And I must say that, first of all, if it's just to use anonymized and aggregate data, it's not a problem. And so to fight against the pandemic, there are many health departments in Europe using that for the moment. So, and we don't have any concern about that. It's just to follow, like you said, the evolution of the virus and the spread of the virus in one region, one country, or at the European level. It's quite possible if you organize a process with anonymized and aggregate data. And that is in the GDPR without any problem. If you organize also the same process using individual data with a reference to the individual people, of course, there you need the consent of the people. And in those cases, there's no problem to work and to try to develop the situation. It's the reason why, for the moment, we try not only to let many public authorities working with anonymized and aggregate data to find a pandemic, and that's is the case for the moment, but we try also to see what is possible with some apps to inform the population. And that's the problem that we have for the moment. How it's possible to ask to the citizens to download an app on their smartphones to be sure that if one owner of a smartphone is infected by the virus, it's possible to inform all the people who were in contact with him during the last 10, 12 days, in my mind 12 days, but we are in discussion about that, due to the fact that it was possible to have a contact through Bluetooth. And so if it's with the consent with the people, it's not a problem. Of course, there are some ideas in other parts of the world to use the geolocalization without the consent of the citizens. But in my mind, it's very dangerous to start such an evolution. We need to try to work with anonymized and aggregate data or with a real concern. And you know, in a very efficient fight against the virus, we need to have the trust of the citizens. If you don't have the trust of the citizens, it's very difficult to organize the different processes. We need to convince the citizens that we are working in a full transparency and that they are well informed about the use, or in such a case, their personal data. There are some exceptions in the GDPR, but I'm sure that here we'll have a large participation of the citizens if we are organizing the fair process and we want to reach the trust. But you're right, there are many other applications when it's possible to use to find the pandemic, and that is without any use of individual data, without consent of the people. It's just we anonymize data, and that is the fact since some weeks.
In fact, we have a related question from Francois Lebay. Are recommendations and guidance to member states for the so-called tracking enough? Can sanctions be applied on the basis of GDPR? Are data protection offices across the EU involved in these discussions and guidance?
But we are more speaking about tracing than tracking. That's the difference. We are using apps with Bluetooth. There are some discussions to see if it's possible to use also the geolocalization, but with a real framework. But so we'll put some limits. And I said this week we are at work, and I want to thank the Open Data Protection Board, because it was a huge work. Also during Easter, the last 2 days, they've worked with my services, the DG Justice, with the national authorities involved in the process of data protection, to see what are the real possible limits of the use of those apps. But when it will be possible to fix the limits, what kind of sanctions? We have national data protection authorities, and so it's possible for the National Data Protection Authority to react. We have also a board at the European level. If we try to do something in the European institutions, we have also a supervisor at the European level to see if it's in full compliance, in fact, with the GDPR. And at the end, it's also possible to have some prosecutions, but we are not so far. For the moment, we try to convince all the member states to use, I repeat, anonymized data and aggregate data in the way to publish and to use statistics about the spread of the virus and to follow the situation, or to put on the market, if I may, to put in the hand of the citizens apps with their consent. And that's the most efficient way. And of course, after that, we will have some limits in the interpretation of the GDPR, and it's the task of the national data protection authorities to verify the situation, and the board will also monitor that, because we have a network of national data protection authorities.
Right. I would now like to invite Philippe de Buc to ask his question. Nathalie?
Bonjour, Monsieur le Commissaire. Heureux de vous revoir en bonne forme. My question is the following, coming back to your annual report on the rule of law in all the member states. Is there not a danger, because we know the countries that don't respect really the rule of law, is it not a danger by starting that process that you dilute the whole issue among all the member states, and that you will create a kind of reluctancy from the member states to proceed further and to decide on some sanctions? And I have two other comments or questions that are perhaps not completely related to the issue. It's one, how to react on the member state that take measures due to the exceptional circumstances to limit the four freedoms of the internal market. And second and thirdly, you mentioned that the 22 member states have taken exceptional measures due to the circumstances. Do you think that the Commission is well equipped to play its role in this circumstances? That should they have some exceptional measures? Thank you.
No, thank you. First of all, about the report, it's an additional tool. We have a toolbox to try to protect the rule of law, but we need to organize a real debate with all the member states. Till now, it was just possible to introduce infringement proceedings to the Court of Justice, and it's fine, because I said again about Poland, it was possible this year, at the beginning of the year, to ask interim measures about the disciplinary procedure in Poland against judges, and we have had a very good decision of the court asking to suspend the different procedures. But we have that, we have the Article 7, but of course, we are sure that we need also to install a real capacity to have a culture of the rule of law in all the member states. And it's the reason why I insist for the third time about the fact that the report will be discussed not only in the European institutions, but also at the national level. And if it's impossible to have a real debate in the national parliament or regional parliament, we'll try to do that with the civil society. Because if I may, I will take an example. Due unfortunately to the murder of a journalist in Malta, it was possible to see some changes in the society in Malta. But it was not just due to some reactions from Brussels, like I've heard sometimes. It's also with a real change in the civil society in Malta and the request from the civil society to move. And of course, the final goal is to organize such a discussion. And it's the reason why we support the civil society in many member states to take part in the debate about the rule of law. And about your question, of course, it's not a dilution. It will be an equal treatment of all the member states, but if it's needed, we will use the other tools. We will go to the court, we will use the Article 7, and maybe, I said, if it's possible to receive an agreement in the Council and in the Parliament, we will use a sort of conditionality about the funding, because the funding is maybe the key element to have a real pressure on the member states. And about the internal market, it was a huge work of some colleagues in the Commission since the beginning of the crisis to try to let functioning the internal market. Of course, the limitation of the four freedoms, the freedom of movement for the people, there are many limitations, it's true, because we have decided in many member states to ask the people to stay at home. So it's a real limitation of the freedom of movement. But is it necessary and is it proportionate? The decision was yes in many member states and with some results if we are looking to the figures now about the pandemic. But for the goods, it was a real concern. It was difficult to organize green lines at the border between some member states who have a fluent transportation of the different services, of the different goods. And I'm thinking, first of all, about the medical goods. I know that many commissioners have taken initiatives to ask the member states to let some green lines at the border or to open the border. Again, we have had many discussions with Poland. I know that the President of the Commission, Ursula von der Leyen, took the time to take to have many discussions with member states to be sure that it's possible to have a correct functioning of the internal market. But you're right, it was not easy during the crisis when we discussed to close the border outside of the European Union, but also to close some borders inside. We need to make the difference between a correct functioning of the internal market for goods and, of course, a decision to stay at home. And last but not least, I want to pay tribute to the services of the Commission. It's true that to monitor the situation in all the member states, certainly the 22 who have decided to take exceptional measures, it's a huge work. But I must say that in 1 week, I've received a first report of the DG Justice about all the different laws adopted in the member states. And now we are monitoring the measures taken in application of the law. But it's a normal way. It's a huge job. I must say that we have the support of the Secretary General in the Commission, the legal service, and we try to follow the situation in the different member states. But you know, during a normal year without a crisis, we need to follow all the different measures taken in the member state to be sure that they are compatible with the EU law. And if it's not the case, we try to start infringement proceedings. But thanks for your question, because I know that it's a huge work to do that. And there are many people at work in the DG Justice to follow that in good cooperation with the representation of the Commission in the member states. And of course, again, there also we are very open to receive remarks, observations from the civil society about the measures taken in the different member states.
Thank you, Commissioner. I think I'm going to take one more question from those who have raised the hand, and that's Alexander Fanta.
Can you hear me all right?
Yes.
Okay. So my question concerns the long-term effects of the current corona measures on EU law. So the Commission right now is has an upcoming evaluation of the General Data Protection Regulation. And my question is, should the crisis lead to a loosening of data protection rules and also kind of fundamental rights to privacy, or you know, what is your take on how the Corona measures, the discussion right now, will affect the GDPR evaluation?
But I'm sure that we will have many changes after the crisis, and that first of all, we need to stick to our main priorities. It's true in many different fields. I want to say that, you know, that we have started with the actual Commission with the Green Deal. And then in February, we have organized a process about a consultation on artificial intelligence. But of course, after the crisis, we need to go back to recovery of the economy with real attention and real and full implementation of the Green Deal. It's needed to work on the Green Deal. It's also needed to use more digital technologies. And so we try to organize the recovery with a better use of that. And you have seen during the crisis, with the webinar, it's the same for the moment. We are using more and more digital technologies, and it will be a real change maybe in the way to proceed later, because we'll have more and more new apps. When you speak about the situation about the fundamental rights or the privacy and the different elements that we have, it's a good opportunity, if I may. It's of course a pity to do that with a health crisis, but we have some exceptional provisions in the GDPR or in other kind of regulations to manage exceptional circumstances. And now we try to fix the limits, and it will be useful for the future to know that, of course, there are normal rules for the normal time, and then we need to see what is possible in exceptional circumstances due to different reasons. And here it's a health problem. And we will fix more and more limits on that. And it's very important because, again, I've had many discussions in the last days about the way to use the data, the personal data of the citizens to find the health crisis. If you don't do that with the trust of the citizens, if you don't manage a mechanism when it's possible to organize a process with the consent of the citizens, you introduce another virus in the system. It will be a virus when the people are not confident that their fundamental rights are protected. And I'm not sure that it's the case. And so we need to be strict on it. But it's true that after the crisis, we will maybe have to change some rules. That's all the time the way to think about that. But more than that, we'll have a better framework in the case of exceptional circumstances. Because if you don't have the expertise of exceptional circumstances, it's very difficult to react. And just to conclude, to make a comparison, it's not the same kind of crisis, of course, but we have had the bank crisis and the sovereign debt crisis. Due to that, it was possible to reorganize different processes about the way to have the functioning of the European Central Bank, or about the different kind of regulations on the financial sector. You have seen at the beginning of this crisis, it was possible for the central bank, to give an example, to react faster. Why? But because we have a kind of guidance about that due to the previous crisis. And here it will be the same. But again, we need to protect the fundamental rights, and we need to protect the fact that the people are confident in the way we are organizing that. And again, I've said that at the beginning of my intervention, is the European way of life, is the Article 2 of the treaty. If we are living in a liberal democracy with a real protection of the fundamental rights, it's true that it's due to the treaties, it's due to independence of the judiciary, but it's due also to the fact that a very large majority of the citizens are confident in the fact that we are protecting their rights. If there are some doubts about that, it will be very difficult to continue. And so you're right, it's possible to change something, but we need to take care also during the crisis and certainly after, that we are continuing to protect the democracy, the rule of law, and the fundamental rights.
We have time for 2 more questions, I think. I'll take, okay, I have another question. Okay, we'll take 3 and then we'll close. Fraser Cameron, you have the floor, sir.
Mr. Cameron, you have to unmute yourself to be able to speak.
Can you hear me now?
Yeah.
Yes, I can hear you.
Okay. Now, the question is more philosophical, about the damage to European integration as a result of the national response to the crisis. And obviously, looking at it analytically, you cannot do this on a national basis. You need a European, you need a global basis. So how confident are you that we can emerge from this with a stronger commitment? Or do you think the commitment to further European integration is now seriously in doubt?
Can I just collect the other two and then we close?
Please, please.
Olena Carbu.
Yes, thank you very much. Do you hear me?
Yes.
Yeah.
Welcome.
Thank you for, yes, thank you for the webinar. I have put the question in written form. Now I will repeat it because I'm dealing with the EU-Ukraine integration, so it's the Eastern Partnership region, and I have a question regarding this particular region. Do you also monitor what is happening currently in the Eastern Partnership countries, which are also unfortunately is not immune from these attempts to misuse the quarantine measures a little bit to squeeze democratic principles and liberal democracy? So our Eastern Partnership countries are also in the area of your concern. Thank you.
And finally, I'd like to read a question from Frank Hofmeister. He's saying, Dear Commissioner Reynders, the two Article 7 procedures are stuck in Council. On Poland, the European Court of Justice delivered important judgments, including the last one on the disciplinary law. Do you think that the Conference of Europe, likely to start in September, should envisage a formal modification of Article 7 to organize EU supervision more effectively?
I will take maybe the question by the last to conclude with a philosophical one. But about Article 7, of course, in the Conference of the Future of Europe, it will be possible to discuss about new rules. And I'm sure that it's better to organize a process without a possible blockage by a minority. But it's the reason why I said also that it will be fine to have a conditionality in the funding of the member states and the policies with a reverse qualified majority. And that's the way to proceed, of course. But there are many other ideas about the way to organize the protection of the rule of law and the fundamental rights. I want just to say that on the basis of the first annual report, we will start also in September a huge discussion on not only the situation, but the way to promote the rule of law to make some progresses. So it's because the Conference on the Future of Europe, I'm sure that we need to think about a new concept for the conference. It will be not the same conference after the crisis than before. But you're right, we need to find some new tools in our toolbox. About the situation out of the European Union, I want to say to make some comments. First, of course, we are looking to the situation in the Eastern Partnership, like in the candidate countries. It's with some colleagues because they are more in charge of the discussion with the Western Balkans, to give an example, but also with the Eastern Partnership. But it's true that we are monitoring the situation there to see what are the evolutions. And you know that the principle was all the time more for more. Of course, we will see if we are on a good track. I'm not sure all the time about the way to protect democracy, fundamental rights, and the rule of law in those regions. But just to give the example of the Western Balkans, we have decided to organize a new process, and we will start all the negotiations with the rule of law, but we will conclude also all the negotiations with the rule of law. And that's very important because I'm sure that in the future, we need to be sure that the day before the accession, a new member state is in full compliance with the Article 2 of the treaty and with the rule of law, the fundamental rights, and the democracy, because we don't need new transitions or new systems after the accession. For the accession, you need to to fulfill all the rules. And then on the more positive,
you're right, but the issue with the rule of law in the Balkans, for instance, is not what happens on the day of accession, but the week after the accession, and how we prevent this.
But first of all, I must say that there are a lot of things to do before to have a full compliance in many candidate countries. So that's the first concern that we have. And then if we have the accession, is the reason why I've asked since many years, and now we have the capacity to organize an annual report on the rule of law. Of course, if you become to be a member of the European Union, you will take part in the annual report and we'll monitor the situation year after year. So it's an ongoing process. But first, you need to make some progresses before to become to be a member. You know that it's a long process when you are looking to the situation there. And the same when we have a partnership like in the eastern part of Europe, also in the southern part, because the last comment on it maybe is also to say that we need to take care not only about the member states, about our neighboring countries in the east of Europe, Eastern Partnership and candidates, but we need to take care of Africa. And I must say that it's a real concern for the moment to be sure that we will take enough initiatives to have a real strategy on Africa and to work on it, because it will be very difficult for many countries in Africa to fight against the virus, but we will be able, maybe at European level, to help those African countries with some debt relief and with some actions to organize not only the fight against the virus, but also to organize a recovery. And then, of course, on the evolution of the European Union, I want to say that there is a link between all those issues. First of all, I've seen that sometimes it was possible to have some criticism about a lack of reaction of the European Union and maybe of the European institutions about the beginning of the crisis. But I repeat, health, it's a national competence. So we have tried to organize all what's possible at the European level to react. Flexibility on budgetary side, so escape clause and flexibility in the state aids, some common procurements for medical elements, but equipments. But at the end, it's maybe a good occasion to prove that we need to have more capacity to act at the European level. So first of all, it's a problem of competence. Is it possible to organize, to give an example, some storage of masks, of other kinds of equipment at the European level to react in the case of a future crisis? It's not the case for the moment, so we are working on it. But so that's the first element. We need to make the difference between the national competence and the European one, and we try to organize what is possible at the European level. The second element, it's a question if we want to have a solidarity among the member states. It's not evident. You have seen the last discussions in the Eurogroup, but at the end, we have some new mechanism to organize solidarity. We need to be sure that the solidarity is organizing among member states, having exactly the same way to think about the rule of law, the democracy and the fundamental rights. It will be very difficult to ask to one European citizens to be solidar to another one in a member state where there is a lack of democracy or rule of law and respect for the fundamental rights. And it's the reason why the conditionality that I've mentioned is very important, but I'm sure that is in the actual discussions about the solidarity, it's also the case. And in the future, I'm hoping that we will have the capacity to organize a better solidarity in Europe with all those countries affected by the crisis. But of course, if we want to do that, we need to show that it's possible to pay the same attention to the economic recovery plan than to the protection of our values.
Thank you very much, Commissioner. I really appreciate your availability and your frank and insightful answers. We're very grateful for your presence, and I want to thank also to our participants. We've had more than 240 people listening in, so thank you to everyone. We'll come back to you. This issue is not going to go away, I'm afraid. And everyone stay safe and well, and I look forward to welcoming you at our next online events for now.
Thank you. Thank you very much for your invitation, and thanks to all the participants. Thank you. Bye-bye.
Bye.